So, welcome back, sir. In the last class, we have completed the concept of the LLP. So, we'll do the revision. So, by the concept of LLP is introduced, sir. The main purpose of the formation of the introduction of the LLP is to get the benefits of the company, to get the benefits of the partnership. Once upon a time, traditionally, the two types of the business was there. One is traditional company, traditional partnership. In company, we are having some limitations and we are having some advantages like limited liability, separate legal entity, perpetual existence. है ना बच्चों? So in the same way, in traditional partnership, there are some limitations like unlimited liability, and there are also some advantages like flexibility in the management of the partnership, flexibility in the partnership deed. Yes sir, no sir, clear now? So once upon a time, we used to have the very large organizations which will manufacturers, which will manufacture the things, and we used to have the small organizations which will sell to retailers. But nowadays, the new way of doing the business is emerged in the society. So the business is not so small to adopt the partnership, not too big to comply with the Companies Act. Yes sir, no sir. So for them, new type of business is required. New type of the companies, new type of the act is required. So that's why the company's LLP is introduced. So LLP is a combination of the advantage of the company, advantage of the partnership. So from company we are taking the limited liability, separate legal entity, perpetual existence, and from partnership act we are taking the flexibility and lesser rules and regulations compliances. Yes sir, no sir. So let us try to understand the difference between the partnership, LLP, and company. We have made nearly 25 differences beta. So you can able to understand half of the LLP through these differences. So partnership is a traditional way of the doing the business. Company also traditional way, and LLP is a hybrid way of doing the business. Partnership is governed by Partnership Act. Company is governed by Companies Act. LLP is governed by LLP Act. So Partnership Act is contains the 74 sections. Company contains the, and LLP contains only 81 sections. We are taking this feature from the partnership. LLP is a merger or combination of the both company and partnership. And partnership is governed by the ROF. Company is governed by the MCA and ROC. And LLP is governed by MCA and ROC. This feature we are taking from the company. And partnership cannot be NPO. Company can be NPO, but LLP cannot be taken from the partnership. And in the partnership form, the persons are called as the partners. In company, they're called as the members. Here, they be called as the partners, taken from the partnership. And in partnership, minimum 2, maximum 100, as per rule 10, 50. And company set minimum 7, public company, maximum unlimited. And here, minimum 2, taking from here, maximum no limit, taking from there. Then beta few features from company, few features from the. So partnership is not a body corporate, it has no separate legal existence. And company is a body corporate, it has separate legal existence. And LLP is a body corporate, it has a separate legal existence. Here partners liability unlimited, members liability limited. Here also the beautiful feature of the LLP is the limited liability taken from the company. And creators of the firm can sue the partners because firm and partner both are one and the same. Creators of the company cannot sue the company because company alag hota hai, member alag hota hai. And here creators of the LLP shall be creators of the LLP alone but not the partners because LLP alag hota hai, partner bhi alag hota hai. And there is flexibility in the partnership deed. There is no flexibility on the MOA, AOA, and there is a flexibility in the LLP deed. And for admission, retirement, death of the partner firm will be affected. It cannot enjoy perpetual existence, and it can enjoy the perpetual existence, and it can enjoy the perpetual existence because LLP alag hota hai, partner bhi alag hota hai. We have taken this feature from the company. Next, partnership cannot enter into contract in its own name because it's not a person at all in the eyes of law. Partnership is not a natural person. Partnership is not an artificial person. It is not a person at all in the eyes of law. But company is a separate person, it can enter into any contracts including its members. LLP is a separate person, it can enter into contracts with his own partners also. Next, partnership cannot hold the properties in its own name. The property of the partnership will be held in the joint names of all the partners because partnership is not a person. Company is a person, company can hold the properties in its own name. LLP is a person, LLP can hold the properties in its own name. And partnership is created by the agreement can dissolve. A company is created by process of the law, only process of law can dissolve. LLP is created by process of the law, only process of law only can dissolve. And here in case of partnership, lesser rules and partnership is suitable for the small organizations, company is suitable for the large organizations, and this one is suitable for the small and medium range of organizations. And here less rules and regulations, here more rules and regulations, here less rules and regulations, because only 81 sections are there. And here there is a mutual agency between the partners, there is no mutual agency between the members. Here there is no mutual agency between the partners, but there is a mutual agency between the company LLP and so the rights and duties of the partners are decided by the partnership deed, and rights and duties of the members decided by the MOA. Rights and duties are decided by the partner LLP deed itself. And partnership is not a artificial person, company is a artificial person, LLP is a artificial person. It is managed by the partners, managed by the directors, managed by the DPs. If partnership act is silent, contract act is applicable. If companies act is silent, SEBI is applicable. If LLP act is silent, companies act is applicable. And we need not file the statement of solvency with ROF. It need not file statement of solvency with ROC every year, but it has to file statement of solvency with ROC every year. Every year we have to inform to ROC, yes, I am solvent. And auditing is not compulsory. Auditing is compulsory. Auditing is compulsory, but we are having some exceptions also. And partner need not obtain any ID number from the government, and you have to obtain the DIN number. Here you have to obtain the designated partner identification number. Here there is no schedules. 4 schedules are there. 7 schedules are there. Registration is optional. Registration is compulsory. Registration is compulsory. Then let us enter into the main part of the chapter, sir. So this act passed in the Parliament of India on the 12th December, and President of India gave the consent on the 7th August, and it is published in the official gazette on the 9th January. He may ask in the MCQs. And the preamble means summary of the whole act in one line. So this act contains the provisions for the formation of LLP, regulation of LLP, and other matters related to LLP. It contains 81 sections and 4 schedules. Out of these 4 schedules, Schedule 1 deals with rights and duties of the partners and LLP. This will be applicable if there is no LLP deed. And Schedule 2 contains the procedure for conversion of the LLP into firm into LLP. Next, private company into LLP. Schedule 4, unlisted public company into LLP. Listed company cannot convert it into LLP. And regulatory body, LLP is governed by the MCA, ROC, and CG has a right to make the rules. So Minister of Corporate Affairs along with the ROC will regulate the LLP Act, and CG has a right to make the rules. In Companies Act rules are there, no? Like Companies Act, LLP Act also may have the rules in the future. CG has a right to make the rules. And LLP Act is amended on the 13th August 2021. This concept is very important, sir. So what is the need for the LLP? Why the concept of LLP is introduced in the society? So LLP Act is introduced to meet the contemporary growth of the Indian economy. Contemporary means dynamic growth of the economy. Economy is changing, way of doing the business is changing. We require a new vehicle for doing the new business. So it is an alternative to traditional partnership, traditional companies, because it can allow you the entrepreneurs to do the business more flexible, innovative, and efficient manner. Here you can enjoy the limited liability of the company, flexibility of the partnership. Yes or no, sir? Since there is a flexibility of the partnership deed, and LLP deed, and limited liability is there, no, it is suitable for the small and medium range of the organizations. Done. Next, the same thing, but it has limited liability and flexibility. So LLP is a separate legal entity. It will be liable for its own assets and liabilities. Yes or no, sir? For liabilities of the LLP, partners will not be liable. It is a hybrid between the company and the partnership, because it has the features of the both partnership and the company. And from here he is asking in the exam beta definitions. Exam mein aa raha beta. Address means address of the partner. Address means address of the partner. If it's an individual, no beta, residential address of the partner. If the partner is a body corporate, no, register office of the such partner. Then next, body corporate exam mein aaya beta already. So body corporate means artificial person. Body corporate means artificial person. Simply, body corporate means company formed in Indian company, foreign company, Indian LLP, foreign LLP. So body corporate means Indian company, foreign company, Indian LLP, foreign LLP, but not the corporation as a sole, like a sole trader, but not the cooperative society or any other body corporate specified by CG, are not the body corporate. So body corporate means Indian company, foreign company, Indian LLP, foreign LLP only, but not the corporation as a whole, but not the cooperative society, but not any other body corporate specified by CG specifically. Done. Next concept. Business. Business includes every kind of trade, occupation and profession, but it will not include any activity specified by the CG. बेटा एग्जाम में आ रहा डेफिनेशंस 3 मार्क 4 मार्क के लिए. Chartered accountant means chartered accountant specified in the ICA Act in section 2(1)(b), who has a certificate of practice. Who has certificate of practice. DP means DP as per section 7. Entity means body corporate. Entity means body corporate. It includes the partnership firm also. Entity means any body corporate or the partnership firm. Next, financial year exam में आया बेटा already. Financial year. Financial year means 1st April to 31st March of subsequent year. 1st April to 31st March of subsequent year. However, ये देखो बेटा, if establish 1st April to 31st March of subsequent year, but if any LLP is formed after 6 months, April, May, June, July, August, April, May, June, July, August, September. If any LLP is formed after 30th September, after 30th September in this period, it should not be counted. It should not be. For them, financially it starts from the 1st April 26. 1st April 26. Then general financial year means 1st April to 31st March. However, if LLP is registered after expiry of the first 6 months, after expiry of the first 6 months, these 3, 4, 5, 6 months should not be counted as a financial year. Then that means financial year should be more than the 182 days. Come se come. Clear? Hello. Foreign LLP means registered outside India, having place of business in India. बेटा ये फाइनेंशियल कॉन्सेप्ट एग्जाम में 5 मार्क के लिए पूछो बेटा. डन. नेक्स्ट LLP. LLP means LLP registered under this act. LLP agreement. LLP agreement means agreement between the LLP and partners. LLP and partners and partners. Between the partners, between the LLP and partners. Name. Name means name of the partner. Name means if it's an individual name, it includes surname, middle name and surname. If the partner is a body corporate, register address, register name. Partner. Partner means any person. Partner means who becomes a partner of LLP as per the LLP Act. Next, RD, regional director. RD means RD appointed under the Companies Act. RD appointed under the Companies Act. Whenever the LLP Act is silent, no, Companies Act is applicable. So RD is not defined in the LLP Act. So who is acting as a regional director under Companies Act, the same guy will become the RD for this act also. Next, registrar. Registrar means registrar appointed under the Companies Act only. It includes additional registrar, joint registrar, deputy registrar and also assistant registrar who is appointed under the Companies Act. Small LLP very important. As so many times in CA Foundation, CA enter also. So LLP, small LLP means LLP whose contribution does not exceed 25 lakhs or such as the higher amount as may prescribed, which should not exceed 5 crores. Right now, contribution should not exceed 25 lakhs. This 25 lakhs limit can be increased up to 5 crores by minister, not parliament. And is there between the what is there and not or, both the conditions must be satisfied. Turnover should not exceed the 40 crores. This 40 crores can be increased up to 50 crores or 40 lakhs to 50 crores. Right now the limit is 40 lakhs. How much beta? Or A plus B or any other requirement specified by the CG in the future if required. So right now an LLP can take the license as a small LLP if contribution is less than 25 lakhs, turnover is less than the 40 lakhs. This 25 lakhs can be increased up to 5 crores and this 40 lakhs can be increased up to 50 crores. Till now clear? Important from exam point of view beta. CA Foundation maybe CA enter maybe came so many times already. Next heading, tribunal. Tribunal means NCLT created under the Companies Act. Applicability of the Companies Act. Whenever the provisions of the Companies Act is silent, no. Whenever the provisions of the LLP Act is silent, no, we apply the provisions of the this act is not applicable to Partnership Act is not applicable to LLPs. LLP Act is also not applicable to partnership. Partnerships are governed by Partnership Act. LLP is governed by the LLP Act itself. Done. Next, features of the LLP. LLP is a body corporate. That means an artificial person. LLP will have the perpetual existence. Partners may come, partners may leave, partners may retire, partners may die, but LLP will remain same. Exam may beta, A B beta, unfortunately. So LLP is separate from its partners. For the activities of the partners, partners are liable. For the activities of the LLP, LLP itself is liable. There is no mutual agency between the partners, but there is a mutual agency between the LLP and partners. Then if partner does something, LLP is liable. If LLP does something, partner is liable. Then, but one partner does something, other partner will not be liable. It is governed by the LLP agreement. If LLP agreement is silent, no, schedule 1 will be applicable. So LLP is a artificial person in the eyes of law. It can do everything what a natural person can do, except getting married, getting sick. Yes or no, sir? So LLP may have the common seal, but it is not a mandatory. It may have common seal, it may not have the common seal, it may have. Next, the liability of the partners is limited to the extent of the agreed contribution. But in case of partnership firm, unlimited liability beta. And management of the business. Partnership is managed by the partners, but LLP is managed by the designated partners who are designated for the management. Minimum 2, maximum no limit partners, and it can be formed only for the purpose of the business, but cannot be chartable organization. If LLP does any wrongful activity, CG has a right to investigate the affairs of the LLP. And LLP may enter into compromise agreement. Which agreement? With creditors or the members if the financial position is weak. So how to enter into compromise agreement, we will discuss it at the end of this chapter. And conversion of the LLP. A firm can convert into LLP, private company can convert into LLP, an unlisted company can convert into LLP, but not a listed company. So documents will be filed with the ROC can be filed physically, but we can also file through the www.mca.gov.in. So documents will be filed with ROC can be filed through website, ROC website. Foreign LLP means registered outside India, which has a place of business in India. LLP can be foreigner, it can be Indian also. Next, advantage of the LLP exam may beta. Foundation may be intent may be So advantage of the LLP: easy to form, easy to create, easy to dissolve, easy to manage. Limited liability. Easy to create, birth. Easy to dissolve, death. Easy to manage, life. And limited liability. Which liability? It is works based on the operation of based on the agreement. There is a flexibility in the partnership deed, easy to create, limited liability, and easy to dissolve. Partners. So who can become a partner? Partner may be an individual, partner may be a body corporate, but a natural person cannot become a partner if he is insolvent. If he is a undischarged insolvent, he is applied to declare him as insolvent. This one is court is declared him as insolvent. Proceedings are going on. Here he is making application but not declared as insolvent. And next, following persons can become the partners of the LLP. Individual can become the LLP. The individual may be a resident or non-resident, even he may be a overseas citizen of India as well as the foreign national. So he must be individual, he may be a resident or he may be a non-resident also. And even LLP can become a partner in another LLP. Company can become a member partner in the LLP, including the foreign company. Foreign LLP, foreign companies can also become the partners, but not the cooperative society, but not the corporation as a whole. So who can become the partners? Indian company, foreign company. Indian LLP, foreign LLP, individual, but not the cooperative society, but not the corporation as a whole. Next concept is the minimum number of the partners to form the LLP. Exam may already. So to form the LLP, there must be minimum of the 2 partners. Practical questions also there, beta. Based on this, I explained in the example, no, beta. वो example exam में आया. So Hyderabad is there, one vehicle is there, टक्कर हो गया, मर गया, मम्मी के. I give example, no, वो example exam में आया. So there must be minimum of the 2 partners to form the LLP. Then section 6 will be satisfied, you will be happy, LLP will be happy, everyone will be happy. If number of partners reduced below 2, partner becomes single person. Yes sir, no sir. Act will go 6 months time. How much time? After expiry of 6 months, LLP will be lifted. Such single partner will be personally liable for the activities of the LLP. ये exam में आया practical question, ना direct question. Done. Next, DP कहते बेटा. कौन है? DP. ये so many questions आते हैं based on the DP. Every LLP must have minimum of the 2 DPs. The DPs must be individuals. Out of these 2, one must be resident in India. One must be ये भी एग्जाम आया. If all the partners are body corporates, if all the partners are artificial persons, two artificial persons should appoint their nominees who are the natural persons. They will act as the DPs. Resident in India means who staying more than the 120 days in the previous financial year, but not the calendar year. They must minimum of the 2 DPs. They must be natural. Out of these two, one must be resident in India. If all are artificial, they should appoint 2 nominees. Done. Next, who can act as a DP? Who can act as the important designated partner? If incorporation document specifies the name of the DP, they will act as a DPs. If incorporation document is silent, all the partners will act as DP. So one LLP is there, but 10 partners are there. Incorporation document specifies Tahura and Unnati are the DPs. They will act as the DPs. If deed is silent, no, all the partners will act as the DPs. Who is liable for the compliances of the LLP Act? So how to become and cease to be a DP? How to enter as a DP? How to cease to be a DP? We can become the member of the DP. We can become the DP as per the agreement. You can cease as a DP as per the agreement. So as per agreement, you can enter as a DP. You can exit as a DP. So before appointing a person as a DP, we have to take a written consent. Why we have to take written consent? Because his liability is unlimited. Done. Next. Details of the DP. Details of the DP should be filed with the ROs within the 30 days of his appointment. If LLP contravenes the provisions of this section, LLP and every DP is liable with the penalty of the 5,000 rupees. In case of continuing failure, 100 rupees per day, subject to maximum of 50 for the LLP, 25 is for the DP. Unfortunately, he is asking the penalties also in the exam. Unfortunately. Next, if you want to become the DP, no, you have to obtain the DPIN number, designated partner identification number from the central government as per section 153 to 159 of the Companies Act. 153 to 159 contains the procedure for issuing of the DIN number. Which number? The same procedure is applicable to LLP Act also, because whenever LLP Act is silent, no, Companies Act will be applicable. So liability of the DPs will be liable for the purchase or sales complying with LLP Act. So they will be liable for all the acts and complying with the provisions of the LLP Act, filing the documents with the ROC, and penalties for the contravention. So you have to manage the LLP, you have to comply the LLP Act. If you are not managing as per LLP Act, you are liable for the penalty. Liable for the penalty. If there is any change of the partners, DPs, we have to inform to ROC. Yes, we have to appoint the new DP within 30 days, and the same thing we have to inform to ROC. If you are unable to appoint the new DP, then all partners are deemed to be DPs. If you are unable to appoint the DPs, no, partner and existing LLP and another DP will be liable for penalty of the 10,000 rupees, and continuing failure 100 rupees per day, subject to maximum of 1 lakh for LLP, 50k for the. Next, incorporation document. Which document, beta? Incorporation document. Incorporation document means application to ROC for formation of the LLP. Application to ROC for formation of the LLP. So we have to give application to ROC. We people want to form the LLP. Can you please allow us? Document. उसको बोलते हैं incorporation document. So it is most important document for registration of the LLP. It must contain the consent of the minimum of the 2 or more persons to do the lawful business and to make the profit, but not the charitable organization. We have to apply to ROC of the state in which register office is proposed to be situated, and we have to obtain declaration from the CA, CMA, CS or advocate in practice that those proposed partners following the procedure prescribed under the LLP Act for formation of the LLP lawfully and legally. What it must contain? This incorporation document should contain the name of the LLP, address of the LLP, business of the LLP, name of the partner, business age of the partner, address of the partner, etc. 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 We have to specify in the LLP this incorporation document. If you are unable to follow above procedure, no beta, unable to obtain declaration, etc., imprisonment up to 2 years and fine 10,000 rupees to 5 lakhs. अंदर डाल देते बेटा 2 साल. Next, incorporation by the registration. Incorporation by registration. So under section 12, LLP takes its birth. Happy birthday. Which birthday? If the requirements of the LLP Act are satisfied, requirements of section 11 is satisfied, that is the incorporation document is filed with the ROC properly, with along with filing fees and registration fees. If the registrar satisfies he will issue certificate of incorporation within the 14 days. How many days? Under his own signature and the common seal. Then LLP is deemed to be registered. It is a conclusive evidence that LLP is registered. No one can question the validity of the birth of the LLP after registration of the LLP. Then next, register office. Which office, beta? Every LLP should have the register office. All the official communication should be sent from the register address itself. Sent from the register address itself. And if you want to communicate something with LLP, you can communicate to register office only through certificate of posting, only through register post, or any other manner. Then so if you want to communicate with LLP, communicate to register office through certificate of posting, through register post, or any other manner. If there is any changes in the address of the LLP, we have to inform to ROC. If you are contravening, penalty will be 500 rupees per day, subject to maximum of the 50,000. Effect of the registration. Effect of the registration, section 14. It is like section 9 of the Companies Act. Once an LLP takes its birth, it becomes body corporate. It can sue. It can sued. It can have the property. It is different from the partners. है ना बच्चों? Sue, being sued, have separate property. It can have common seal. It can do everything what a natural person can do, except marriage. Sadhu ana beta. Name. So every LLP name should contain the words LLP. Acronym are the words called LLP. The name exam questions are there. Ara. One company is there, beta. One LLP is there. One partnership firm is there. SG and Associates. Santosh Ganesh and Associates. Santosh Ganesh and Associates. This was formed in the 1988. When beta? ముందు పుట్టిన 1988. So recently one LLP is registered, beta. Sai and Gaud LLP in the year 1989. Let us remove these dates. ये 2025 में पैदा हुआ बेटा, ये 2026 में पैदा हुआ. अलाउड नॉट अलाउड? SG and Associates is there. It was there earlier. Now new LLP is registered with the name called SG LLP. Both are same, SG. Allowed or not allowed? If it is not allowed, why I will ask? If it is not allowed, why I will ask? Why you spend this much of time? Bhavana. The name of the LLP should not be similar to LLP. Should not be similar to registered. Questions are there. Done? So name of the LLP should contain the words limited liability partnership, or the acronym called LLP. The name of the LLP should not be undesirable in the opinion of the central government. That is, the name of the LLP should not be similar, identical with already existing LLP name, company name, and registered trademark. Reservation of the name. क्या है बेटा? Reservation of the name. Every proposed partner has to make application to ROC. In ROC, one department is there, beta, Central Registration Center. Which center? For reservation of the unique name. Reservation of the, because the name of the LLP should not be similar to name of the existing LLP, company, and registered trademark. Here firm is not specified, beta. Ara bachcho, most of the students can write yes, it should not be, but it can be. In this question, 4 marks, 6 marks I exam mein. That is why we should do the scanner. Scanner is powerful. Scanner is name of reservation of name. Bolo bachcho. Person may apply to ROC for reservation of the name for new LLP. For new LLP, existing LLP is there. It want to change its name. Still, we have to apply to CRC department of the ROC. CRC means Central Registration Center. If we want to form the LLP, existing LLP want to change its name, so we have to apply to ROC for reservation of the unique name. The name will be reserved for 6 months or 3 months. In these 3 months, complete the process of the incorporation, complete the process of changing the LLP name. After 3 months, somebody is asking for the same name, we will allow it. We will keep the kerchief on your name only for the 3 months. How many months? हर एक पॉइंट एग्जाम में आ रहा मित्रों मेरे प्यारे देशवासी. People will live FEMA because it is tough. People will live LLP because it is very easy. I know everything. Done. టఫ్ కాదు రే అట్లా అనుకుంటారు జనాలు. ఈజీ. ఓకేనా కళ్యాణ్? విల్ డూ ఇట్, విల్ రాక్ ఇట్. టెన్షన్ హోనే का नहीं. It is easy provided revising. You know about your brothers, very busy people. They are answering all my questions in the class. Hey Kalyan, tell to your brothers, elder brothers, focus. Your attempt is coming. What is coming? When? January, right? August, September, October, November, December. Only 5 months, 6 subjects. August, September, October, November, December. 5 months, 6 subjects. 150 days. అది ముల్ల 15. 150 days. హెడ్ ఏకు స్టమక్ ఏకు పవన్ కళ్యాణ్ సినిమా, ప్రభాస్ సినిమా, సల్మాన్ ఖాన్ సినిమా. 30 days normal loss. Ganesh, idol keeping. Ganesh going to his home. Ganesh is coming. Ganesh is going. Dasra will come. Durga will come. Durga will go. Yes or no, sir? So mummy birthday, my birthday, your birthday, headache, stomach ache, some other pain. Some days you will get frustrated, irritated, humiliated. One find a girlfriend said, don't talk to me. 30 days normal loss. कितना बच गया बेटा? 120. For how many papers? 6 papers. And paper how many days are there beta? 12. 20 days. For each paper we are having the nearly 200 to 300 pages material. We should come से कम 3 revisions. How many revisions beta? 20 days is. डिग्री भी रहता है बेटा, वो भी निकालेंगे. So కళ్యాణ్, युवराज सिंह, गणेश अन्ना, पेदन्ना, आ अन्ना, ये अन्ना को बेटा के बोलो, अन्ना प्लीज अन्ना पढ़ो, अन्ना प्लीज अन्ना, अन्ना प्लीज अन्ना रेस्पॉन्ड टू श्रीनाथ सर अन्ना. सुनो बच्चों, रेक्टिफिकेशन ऑफ नेम ऑफ द LLP. Rectification of LLP is there. The name of the LLP similar to LLP name, similar to company name, similar to registered trademark owner. Yes sir, no sir. Then CG may ask you to change your name. If the name of the similar to already existing LLP name, company name, or trademark, then CG may order to change your name. Based on the order of the CG, the LLP has to change its name within the 3 months. 1 month, 3 months. And registered trademark owner may also apply to central government if his name is similar to his name. But we have to do this within the 3 years. How many years? From formation of the LLP, new LLP. Then filing with ROC. After changing the name should be filed with ROC along with the order of the CG. Yes sir, no sir. And CG will allot the name. For example, CG is asking you to change your name, but you're not changing your name. Since you're not changing the name as per the CG order, CG itself will change the name of the LLP. Who will change beta? And CG will inform to ROC. ROC will update its registers. ROC will issue new certificate of incorporation under the new name. Next, eligibility to become the partner. Eligibility to become the partner. Subscribers will become the partners of the LLP automatically. Any other partners may become the partner as per the LLP agreement. So generally, subscribers will become the partners automatically. Subscribers means who are trying to form the LLP, they become the partners automatically. And any other person also may become the partner of the LLP as per the LLP agreement. And relations of the partners. So mutual rights and relations of the partners, the rights and duties of the partners are governed by the LLP agreement. Yes or no, sir? Clear now? If there is any changes in the LLP agreement, should be filed with the ROC. If LLP agreement is silent, we have to follow the schedule 1. Cessation of the partnership interest. So how to retire from the LLP? How to retire from the LLP? So a partner may retire voluntarily or the compulsorily. A partner can retire as per the LLP agreement or in the absence of the agreement by giving 30 days notice to LLP. And partner must be retire from the LLP in case of death, in case of dissolution of LLP, in case of unsoundment, in case of the insolvency. Partner should and must retire from the LLP. And if a partner is seized, no, we have to inform to partner has to inform to LLP, LLP has to inform to ROC. The liability of the retired partner, ये भी exam में आया बेटा. Even partner is retiring, he continues to liable for the activities of the LLP until we inform to ROC. Until we inform to. So when he is retiring, no, he is entitled to get back his capital contribution and share in the profits. Registration of changes in the partners. Registration of changes in the partners. Suno beta. Partner is changing his name. Partner is changing his address. We have to inform to LLP within 15 days. Partner changing his name, changing his address, inform to LLP within the 15 days. And incoming partner is coming. No, but he has to inform to LLP that I am coming. And he has to give his written consent to act as a partner. And if partner is retiring also, we have to inform to LLP. So existing partner changing his name, inform to LLP, changing his address, inform to LLP, and new partner is coming, inform to LLP. Existing partner is retiring, inform to LLP. If new incoming partner is coming, no, he has to give his written consent also. These things should be done within the 15 days. Then LLP has to inform to ROC within the 13 days, and it must be signed by the DP. Clear? For example, beta, we inform to LLP, but LLP is not informing to ROC. Then retiring partner, he directly informed to ROC. Then ROC will confirm the same thing from the LLP. ROC has to confirm within the 15 days. If ROC will confirm the same thing from the LLP. So LLP has to confirm within the 15 days. If LLP is unable to give any information within the 15 days, ROC will assume that yes, the information given by the retiring partner is acceptable. Clear, madam? Next, partner as a agent. Partner as a agent. So there is a mutual agency between the LLP and a partner, but there is no mutual agency between the partner and a partner. And extent of liability of the LLP. Extent of liability of the, if partner does any activity within the authority of the LLP, which is related to normal course of business of the LLP, then LLP will be liable. Those liabilities can be met out of the LLP assets. If partner is doing any activity which is beyond the authority of the LLP, then LLP will not be. Then clear. Next, extent of liability of the partners. Partners will be liable only for the LLP will be liable only for the intravirus activities, but not the altravirus activities. One partner will not be liable for the wrongful activity of the another partner. Then next, partner by holding out. Partner by holding out. If non-partner is represented as a partner of LLP, he will stop that. If he is unable to stop that, no, he will become partner by holding out. He will be liable for the activities of the LLP. Next, unlimited liability in case of the fraud. In case of the fraud, in the event of any activity carried on by LLP partner with the intent to defraud, then the liability will become unlimited. If partner is doing any activity, LLP is doing any activity with the intent to defraud the creditors or customers, then partner liability, such partner liability and LLP liability will become unlimited for the transaction. Done. And in case of the fraud, imprisonment up to 5 years, fine 50,000 rupees to 5 lakhs rupees. If partner is deceased, no, but after death of the partner, even his legal dependent will not be liable for the activities of the LLP. Then after death, deceased partner's legal dependent will not be liable for the activities of the LLP. Where LLP or any partner or DP or employee of the LLP has conducted the affairs of the LLP in a fraudulent manner, you have to compensate the loser because of the fraudulent activity of the LLP or the partner. If anybody is getting a loss, no, you have to compensate his loss. Next, whistleblower concept came in the exam 2-3 times in the exam, beta. Very, very important. Whistleblower is a person who is going to the society along with corporate abusers. Something bad is happening in the organization. is going to the society along with those abuses, उसको बोलते हैं whistle blower. Yes or no, sir? So there was a investigation on the LLP because their government is getting a doubt that they are doing some unlawful activities. If any partner, if any employee supporting the investigation, providing the information, supporting the investigation, providing the information to government or investigator, such kind of the partner, such kind of the employees are said to be whistleblowers. These people should not be, those partners and employees should not be discharged, should not be demoted, should not be suspended, should not be threatened, should not be harassed, should not be discriminated. We have to give the protection to that kind of the whistleblowers. Exam mein aaya. Next, form of contribution. Form of contribution of the partner. Every partner has to contribute to agreed amount. So the contribution can be tangible, intangible, movable, immovable, money, promissory note. It can be agreement to contribute cash. That means right now I am not giving, I am giving the future. And it may be include the agreement to provide the services. Instead of the money, I will give my free services to LLP for few days. Then so every partner has to contribute as per the LLP. Next, maintenance of the books of accounts. Every LLP has to maintain the books of accounts. Every LLP has to maintain the books of accounts every year on a double entry system on cash basis or the accrual basis at the register office of the company. And every LLP has to file the statement of accounts, statement of solvency, that is P&L account, and also we have to inform to LLP that we are solvent, we are not insolvent. Who has to inform? Every LLP. To whom? ROC. When? Within the 6 months from end of the financial year, it must be signed by the DP. And when we are filing something with ROC, we have to file it with registration fees and filing fees. And for LLP, auditing is not compulsory if turnover exceeds 40 lakhs, contribution exceeds 25 lakhs. Otherwise, auditing is not compulsory. LLP, when it is compulsory, but auditing turnover exceeds 40, contribution exceeds 25. Otherwise, it will not be. Next, every LLP has to follow the accounting standards. Every LLP has to follow the accounting standards. Accounting standards and auditing standards may be prescribed by the central government in consultation with NEFRA. Right now, there is no specific special accounting standards and standards and auditing for LLP. But in the future, CG may issue the special accounting standards for LLP, special standards and auditing for LLP in consultation with the NEFRA, National Financial Reporting Authority. And every LLP has to file the annual returns with the ROC within the 60 days. How many days? Annual returns means annual returns as defined in the Section 92 of the Companies Act. Next, inspection of documents kept by the registrars. So, LLP will file a lot of information with the ROC. ROC is a public office. Documents filed with the ROC will become the public document. Any person can inspect the information of the LLP from the ROC on payment of the prescribed fees. On payment of the, if you are filing any wrong information to ROC, filing imprisonment up to 2 years, fine 1 lakh rupees to 5 lakh rupees, minimum 1 lakh, maximum 5 lakhs. Power of ROC to obtain the information. If ROC requires any information, ROC may obtain the information from LLP, from present partner or former partner, from present DP or former DP, from present employee or the past employee. First, if the ROC requires any information from the present and past employee, present and past partner, present and past DP, first ROC will give the notice. You have to respond to notice. You have to provide the information. Otherwise, ROC will give the summons. Summons means legal notice to present before him. So ROC may ask you to come to his office, present before him to provide the information. And ROC is giving the notice, not responding. ROC is asking for the summons. You are not going to ROC office also. Then you will be punishable with a fine of 2,000 rupees to 25,000 rupees. Next, compounding of the offences. Compounding of offences means out of court settlement. In order to avoid the imprisonment, so you can talk to the both the parties can discuss. They can close the issue. उसको बोलते हैं compounding. There are two kinds of offences: are the compoundable offence, non-compoundable offence. If it is a murder, if it is a rape, non-compoundable offence, you have to go to jail for sure. If it is a small theft, है ना बेटा? You can compromise with the defaulter and the aggrieved party can discuss. They talk to each other. They can pay some damages. They can close the matter. उसको बोलते हैं compoundable offence. Which offence? So offence under the LLP Act are compoundable. Defaulter has to apply to ROC. ROC will forward the same application to RD. and RD may compound the offense. After compounding of the offense, the same thing should be filed with ROC within the 7 days. So defaulter may has to apply to ROC. ROC will forward the same application to RT. RT may compound the offense. That means instead of the imprisonment, instead of the legal proceedings, instead of the prosecution, let us settle the issue in the beginning stage itself. And if it is compounded, no, the same thing we would inform the ROC within the 7 days. And once a person commits any default, if it is repeated within the 3 years, it cannot be compounded. It cannot be done, na beta, because you are habituated to that kind of defaults. Then clear. Next application. Already acted. Next. Now prosecution. Yeah. Once you are compounding, no beta, there will not be any prosecution. There will not be any further prosecution. We can also start the project. We can also compound after starting of the prosecution. So if you are you can do the compounding. You can be done before prosecution. When beta? Before prosecution or during the prosecution. If you are compounding before prosecution, there will not be no further prosecution. There will not be no further prosecution. If during the prosecution, if you are ready for the compounding, no, the prosecution will be dropped. Then it will be discharged. Prosecution will be discharged. Next, assignment and transfer of the partnership rights. Assignment and transfer of the partnership rights. So rights of a partner can be transferred to any other person, either wholly or the part. ये भी exam में आया बेटा. Whether written or not, I don't know. देखो. So these things is asking in the exam beta. One partner is there. One partner want to transfer his shares to third party. Can he? Yes. So the rights of a partner can be transferred either wholly or the partly. Transfer of the right by partner will not lead to winding up of the LLP. Why? Because LLP अलग होता है, partner अलग होता है. Partnership form will be effective for admission determinant, but LLP will not be affected. And just because of the transferee cannot participate in the management, cannot participate in the exam में practical question है, direct question नहीं. The share in the partner LLP form, LLP can be transferred. Even share is transferred, LLP will not be reconstituted. The same LLP will remain same. And just because of the transferee will not manage the LLP because of he is not a DP. He is not a. Next conversions. A firm can convert it. Suno beta. Conversions. A firm can convert into LLP as per Schedule 3. A private company can convert into LLP as per Schedule 3. Unless a public company can convert into Schedule 3. If you want to convert as LLP, no, firm has to inform to ROF. ROF will remove the name of the firm from register of companies. Private company has to inform to ROC. ROC will remove the name of the private company name from register of the companies. Unless a public company has to inform to ROC, they will remove the name of the public company from the register of companies. Then after conversion, LLP has to inform to ROC. They will issue new certificate of incorporation as LLP. Then convert the private company has to inform to ROC. They will issue new certificate of incorporation as LLP. Unlisted public company has to inform to ROC after conversion. So they will issue new certificate as a LLP. So because of this conversion, partners of the firm, members of the company will become the partners of LLP, and employees of the firm, employees of the private company, employees of public company will become the employees of LLP. Assets of the firm company will become the assets of LLP. Liabilities of firm will become the liabilities of LLP, and cases filed by firm company, cases filed on firm company will become the cases on the LLP, and the properties will be transferred from the firm to LLP, company to LLP without further registration, and ROC will issue new certificate of incorporation under the new name. Done. Next topic is the compromise and arrangement. Compromise and arrangement and reconstruction. Compromise, arrangement and reconstruction. LLP may enter into compromise and arrangement agreement with creditors and partners. What is the concept of compromise and arrangement? For example, beta, one LLP is there. LLP has to pay 10 lakhs rupees to Ganesh. Yes sir, no sir. So LLP is having only 4 lakhs. LLP is having only 4 lakhs. Partners ready to contribute 1 lakh extra. है ना बेटा? इसको बोलते हैं arrangement. Partners ready to give 2 lakhs extra. Still 4 lakhs is pending, no beta? Then Ganesh said, I'll compromise. So at least pay 4 lakhs. At least pay the 6 lakhs. You needed to pay remaining that 4 lakhs. उसको बोलते हैं compromise. उसको बोलते हैं creators may compromise, partners may arrange. So we may enter into compromise and arrangement agreement with creators or the partners. If you want to go for the compromise and arrangement agreement, the proposed person, that can be partner, that can be LLP, that can be creator, has to make an application to NCLT. NCLT will appoint the official receiver or the liquidator. The liquidator will call for the meeting of the creditors. And liquidator will frame the scheme. The scheme is, so we can't pay 10, we can pay maximum 6 or 7. Yes sir, no sir. It must be accepted. It must be accepted by the 75% of the creators in value, not number. By the 75% in value. And after that, the scheme will be presented before the NCLT. NCLT may accept the scheme if LLP is presenting the assets, liabilities, cases, pending cases and etc. clearly. If they are showing all the financial, all the effects properly, so NCLT may approve the scheme. If it is workable, they will sanction. If it is not workable, they will not sanction. And after that also, NCLT will review whether it is workable or not. If it is workable, they will allow further. Otherwise, they will go for the resolution of the particular LLP. Then this is new concept, beta, very important concept. Next, provisions for the facilitating the reconstruction of the LLP. Reconstruction of the LLP. That means two LLPs are there, beta. GLLP, SLLP, Ganesh LLP and Sweet LLP. If these are joined together, उसको बोलते हैं amalgamation, उसको बोलते हैं. So we may enter into this agreement within the LLP or between two LLPs. Within the LLP or between the two LLPs. Within the LLP means internal reconstruction. Between two LLPs means, so we have to make an application to NCLT. We have to make an application to. When we are making the application to NCLT, no beta, it will lead to NCLT may order for the transfer of assets, liabilities from old LLP to new LLP. That is a transfer to transferring. Dissolution of the old LLP transfer without any process of winding up. And the provisions made for the dissenting partners. Which partners are? Out of 10 partners, 9 partners are agreeing, 1 partner is not agreeing. So we have to give the provision for that partner will repay his principal, we will pay his interest, the share of the profits also, he may exit. Next, so NCLT will order for the scheme only if NCLT has a report from the ROC. If ROC also satisfies that the affairs of the LLP is not up to public interest, LLP may order for the amalgamation of the LLP. The property or liability of the transfer will become the properties of the transferee. The order of NCLT should be filed with the ROC for registration. Next, winding up of the LLP exam में आ रहा बेटा. Winding up of the LLP may be voluntary or it may be compulsory due to order of the tribunal. Tribunal will order for the winding up of the LLP if partners are deciding, and 6 months are expired if the number of partners are unable to increase it to 2, and if the LLP is acting upward to integrity of the LLP, integrity of the India. ये भी एग्जाम आया बेटा, डी पॉइंट एग्जाम में आया. If the LLP is unable to file the statement of solvency or statement of annual returns with ROC continuously for how many years? एग्जाम में ये पॉइंट भी आया बेटा. And any other just and equitable grounds like deadlock in the management, loss of the substratum. So CJ has right to make the rules for winding up of the LLP. Right now there is no rules. Business transaction, LLP is a separate person. LLP has right to enter into contract with its partners also. Whenever the provisions of the LLP Act are silent, provisions of the Companies Act will be applicable. But before applying the provisions of the Companies Act to LLP, we have to keep those things in the Parliament for the period of the 30 days. How many days? If the LLP is unable to file any document with the ROC, we can also file beyond the specified date on payment of the additional fees. And if any person committing any default under the LLP Act, and if he is imprisoning him, imposing any fine, no. If he is making the same default second time, no, the fine and imprisonment will be doubled. Twice the amount, twice the imprisonment will be there if he is repeating the same offense. With this, we have done with the LLP Acts. Done.